Hello, I'm John Hartkin, ABI's Public Affairs Officer, and I'm joined today by Erika Morabito of Quinn, Emanuel, Urquhart, and Sullivan. And we're here at Views from the Bench in Washington, D.C. And Erika was just on a panel looking at a number of issues that have been in the spotlight, mass tort bankruptcy cases, two-step divisive mergers, and more. Erika, what are some insights that you gleaned from your panel of judges here at Views from the Bench today?
Yeah, thanks, John. So it was a really interesting panel, frankly. We had judges from different circuits on the panel, which I think always makes for an interesting, not always agreeable panel. But I think everybody seemed to be generally agreeable on these mass tort cases. The first was, is it even allowed for in the code? Because the code specifically says asbestos, and obviously we're seeing mass tort cases in a whole bunch of areas other than asbestos. And I think the general consensus is yes, it is certainly something that bankruptcy courts, while it may not delineate specifically what the mass tort is, that it can be a useful forum in order to resolve some of these cases. I think having sat and prepped with the judges, I think they are unanimous in their view that while it's not perfect, and they're getting bigger and bigger, and these cases are inviting more and more claims, because you have claims lawyers versus litigators. So you've got a lot of claim lawyers coming in and filing claims which probably would not have been filed in the first instance. Some people say, well, that's a good thing, because some of these people otherwise would not have had representation if these weren't being dealt in the bankruptcy case, and that's particularly true with pro se, because the pro se litigants are able to file a proof of claim without counsel. Others are saying, are the courts overstrapped? Is there too many people here, and is this really the best forum for these types of tort cases to be resolved? I think what the judges are saying is, look, there's no question courts are overwhelmed. But it is, bankruptcy is a court of equity. They have the best view on valuation, on claims reconciliation, understanding releases, that if it's not bankruptcy courts, then where would they be done, right? Because at the end of the day, they do have the result of stopping races to the courthouse. They do and can provide finality. There is a mechanism for people to get paid that otherwise wouldn't get paid. It allows you to be able to have more flexibility with the statute of limitations. So I think the answer was yes, we are stretched thin, the bounds are being pushed around the edges, and we're gonna have to deal with those on a case-by-case basis, but the bankruptcy courts can be a very effective forum for dealing with mass torts.
Excellent. It sounds like it was quite a panel discussion today.
It was very robust and active, and the panel, each of the judges got to share their own personal view of their experience with mass torts or reading in the mass tort cases. What a better way than to hear it from them directly.
Sure, and it sounds like these issues are going to continue to
Correct.
evolve. And as they do, make sure to join us at future ABI programs. You can find out about those at abi.org/events. But I'd like to thank you, Erika, for joining us, A, for participating on the panel, and B, for sharing the insights with us today.
Well, I appreciate the invitation to participate. This is one of the best panels. I think hearing it from the judge's mouth like we do in this one, which I think is unique, is great. So I was honored to be a part of it, and thank you very much.
All right, thank you.